The youngest son of Zimbabwe's late former president, Robert Mugabe, has been formally charged with attempted murder at a brief appearance in a South African court. However, the attempted murder case against Bellarmine Mugabe has been postponed. 28-year-old Mugabe and his co-accused Tobias Mugabe made their first appearance in Alexander Magistrate Court. They face charges of attempted murder, defeating the ends of justice, and a firearm possession. This follows a shootout incident a week ago at the Mugabe's house in Hyde Park, Johannesburg. The pair is expected to be back in court on the 3rd of March for a formal bail application. Bellarmine is the youngest son of Robert Mugabe, and his second wife, Grace, who died in 2019, led Zimbabwe for 37 years before being forced out of power at the age of 93 in 2017. Let's take a listen to Bellarmine Mugabe's lawyer.
Degree of confusion with regards to where they were meant to be, but that emanated from the police station where they were being held. It seems that they were sent to the Randburg Magistrates Court instead of the Alexander Magistrates Court, and of course the magistrate wasn't pleased about that, but I mean that was rectified and they were ultimately brought before court.
Let's get more on this. Practicing attorney and lecturer in criminal procedure, Wits University, Johannesburg, Professor Stephen Toussaint joins us from Johannesburg. Professor, thanks for joining us today. Great to see you.
Good evening.
Right, so given the charges of attempted murder, defeating the ends of justice, and illegal firearm possession, how serious is young Mugabe's legal exposure under South African law?
These are very serious offences for which the maximum penalty can be handed down in terms of a period of imprisonment for 15 years under the minimum sentencing legislation. There can be nothing more serious other than actually murder, which this is attempted murder because the victim has not deceased.
Right, and the case has been postponed for a formal bail application on March 3. What factors will the court consider in deciding whether to grant bail, particularly in a case involving a firearm and an alleged shootout in Hyde Park?
There are 5 factors which the court should take into account. One of them is the seriousness of the offence, which is very serious. It's attempted murder, and here the court will consider whether he poses a risk of danger to the community, which is clearly the case in such a serious charge. Another factor the court will look at is whether he's a flight risk. In other words, if released, will he abscond and evade his trial? The fact that he's a foreign person with his immigration credentials are called into question, he may be illegally in the country, and that he's from a foreign country strongly mitigate against him getting bail, because if he flees the country, there's very slim chance of getting him back to stand trial. So my opinion is that it will be very difficult for him to receive bail because of the seriousness of the offence, the fact that he's possibly illegally in the country, he's a foreign national, he's potentially dangerous to the community. I think he would have really difficult to get bail.
Right, and we have a case of circumstantial evidence here. The missing gun is essentially an important and critical piece of evidence. If the weapon is not recovered, how could that affect the investigation and any potential prosecution?
It certainly is a very important piece of evidence, but it's not conclusive in the case as a whole. So we need to define what is circumstantial evidence. We can contrast circumstantial evidence with direct evidence. Direct evidence is where, for example, somebody observed him shooting the victim. An eyewitness who can say directly, this is what I saw. That is strong direct evidence. Circumstantial evidence is not direct, where you don't have a witness who actually saw the shooting. There are facts surrounding the shooting which strongly point to the suspect, and the process here is where you draw inferences from the facts. So the fact that they may, if they find the gun, match the gun and the bullets to the victim, the bullets any bullets that were found in the body of the victim, the casings match the gun, and fingerprints are on his gun. These are all facts which are circumstantial, but they strongly point to a conclusion that he may have or must have been the shooter. The problem with circumstantial evidence is that you cannot convict on circumstantial evidence if there is any other possibility which can explain those facts. So if any other reasonable possibility exists that he was not the shooter, then he would be entitled to a acquittal. So yes, the gun is important, but it is just one further piece of evidence which would go towards suggesting that he is probably the shooter. But we know, for example, that his bodyguard was also arrested, and so he could have been the shooter, and we don't really know.
Yes, and the fact that, some other possibly, witnesses, neighbors heard that the young Mugabe had an argument with the victim. Gunshots were heard in Mugabe's yard outside the gates. The victim is known to Mugabe. So, I mean, how important is this factor in the case against him?
These are all very, very damning facts. The fact that they are known to each other, the fact that there was, I suppose, direct evidence that there was an argument, that I understand that he refused to let the police in. I don't want to repeat that as fact. I think that's a possible fact. And the gun is now suddenly missing. Very suspicious behavior. And these are all factors which can assist the court in drawing a conclusion that he must have been the shooter. So you can see there's no direct evidence that he is the shooter. But all of these small pieces of evidence combine for the court to draw an inference that he was the shooter. But I stress, to get a conviction, the conclusion you seek to draw of guilt must be the only reasonable conclusion. And if any other explanation is possible, then he will be entitled to an acquittal.
Right. And, drawing from what you've just said, obviously the prosecution too will have, a very, very damning case against him, considering that Bellarmine Mugabe is a foreign national. He's the son of Zimbabwe's late former president. Could issues such as flight risk, diplomatic sensitivity, or political profile influence the court's approach to this case?
The political profile should not have any impact at all on his release on bail. We're all equal before the law. I'm not too sure whether he is a diplomat and is entitled to diplomatic immunity. I don't think that he was employed by the Zimbabwe government in any capacity whatsoever. But we know that Grace Mugabe escaped prosecution for a very serious assault in South Africa by suddenly being granted diplomatic immunity. And so who knows what can happen in this case. But I would say that absent any immunity from the Zimbabwe authorities, it would be extremely difficult for him to get bail because the charge is very serious. It's the possibility that he poses a danger to the community. He's already illegally in the country, which means he's a flight risk. The fact that he's a foreign national who has a home in another country means he has somewhere to flee to. These are factors which strongly indicate that he should not be given bail, because if he does, he poses a flight risk.
And finally, as I let you go, the victim too has indicated that, does not remember who shot them. How does this impact the case?
Yeah, that is a serious deficiency in the state's case. But as I indicated, that just means that there's no direct evidence against him as to who shot the victim.
Yeah.
It is possible to achieve a conviction from circumstantial evidence, and there is strong circumstantial evidence against him to suggest that he is possibly the shooter.
Right.
So it is possible to get a conviction, but it must be the only reasonable conclusion that the court can draw.
Right. Practicing attorney and lecturer, criminal procedure, Wits University, Johannesburg, Professor Stephen Tucson. A pleasure again having you. Thanks for joining us.
It's been a pleasure to be with you. Thank you.